What's up, everybody? We have another twist in the Sarah Boone case after the court has found that she has forfeited her right to court appointed counsel and must either represent herself or find her own attorney. We all assumed it would be the former. Turns out it may be the latter. Sarah Boone, new attorney, notice of appearance, and his first motion filed should be no surprise to any of us who have been following this case. Let's get into everything that's happening in Sarah Boone. Before we get to her new lawyer, a couple other things have happened in the last literally 2 or 3 days in Sarah Boone. We are going to run through and then spend the majority of the video talking about her new lawyer. First is the order setting hearing for September 3rd, which is next week, 9 a.m. And what are they going to do? What motions are we going to deal with? Well, they're going to review the state's physical evidence. Are they doing that in the courtroom? Are they doing it at the jail? Not really sure, because this says the location is at the courthouse. Will there be media there? I thought they were doing it at the jail. Maybe there's something I'm missing here. Second is the motion for payment of costs and appointing a neuropsychologist to assist defendant in preparing her defense. So this is the expert witness for probably a battered spouse syndrome, something to that effect and nature. And they've also filed this notice to JAC so they can be there and be heard and figure out how much money, if anything, they're going to give to Sarah Boone. Next up, we have a very interesting document. A lot of you sent me. I wasn't really planning on doing a full video on this because it's kind of strange and I don't really get it. I mean, I guess I understand what they're saying, but it doesn't make a lot of sense. Let's take a look at it. Authority, the Constitution. This is a motion to dismiss, okay? Authority, the Constitution of the United States, Amendment 6, specifically the right to a speedy trial, has been violated. The state of Florida has not met the requirements or proven good cause of the delays. Ineffective, substandard state-provided attorneys should have made this request long ago, proving this as a fact. So I don't really know who filed this, if it was Tiffany Moore Russell, or no, this is the JA, right? Tiffany Russell, is that the JA? Why does that name sound familiar? I don't see a certificate of service on this, so I'm not sure who filed this. Maybe you guys know, but it's attention Sarah Boone. Was it her new lawyer that filed it? I don't think so. This does not look like it was written by a lawyer. But we'll get there. Okay, then she puts in the Sixth Amendment where it talks about her right to a speedy trial. So let's just talk about this for a second. Okay, assuming this was a legitimate motion. She waived her right to a speedy trial. That's been confirmed. Okay, so that's one of the problems with this. But even if you waive your right, you can demand it later. And if the court finds that it's so obviously a delay attributable by the state, potentially you could have violated your speedy trial right. Problem is, continuance after continuance has been asked for by Sarah Boone. Yes, by her lawyers, but they speak for their client, Sarah Boone. And guess what? Arguing this and filing this motion for a speedy trial is ironic when we talk about what motion her new lawyer just filed, which is how I'm pretty sure her new lawyer didn't file this motion. Not just because it looks like it isn't filed by a lawyer. Okay? So let's see what the judge thinks about this motion to dismiss based on her speedy trial right. Well, the court has struck this motion, this cause having come to be heard before me in chambers on August 29th, the motion to dismiss with constitutional authorities filed on August 27th, and the court having reviewed the motion and the court file and being otherwise duly advised in the premises hereby finds as follows. The motion was received by this court on August 27th. The motion was filed by a non-party. As such, it is therefore ordered stricken. Out. So a bunch of people asked me about it. I was like, this doesn't make any sense. I can't tell who filed this. Clearly wasn't her lawyer based on other things we know. And the judge has quickly, summarily denied and struck. I guess he didn't have to deny it because he struck it. Okay? We're moving fast and furious here. All the stuff that's going on. Then we have this document, which is a notice of filing the IMS report of the Orange County Jail per the memorandum from the Orange County Corrections Department. So what this is every time she is handed, this is the log where she's given her computer and her USB. But the interesting portion is here. On August 19th, Boone is currently pro se and is allowed a laptop per scheduled hours of the day. Inmate Boone, currently pro se, is allowed a laptop. The laptop had a low battery and needed to be charged. An entry was made hours ago by this officer regarding the battery and also Inmate Boone requesting an OP 60 statement form. While collecting the form, Inmate Boone, I informed to her that the laptop is now charged and should be ready for use in the morning. I also told her I will make the day shift officer aware that the laptop is to be charged once she's finished with it so that she can utilize it during the night shift. Inmate Boone stated, Miss Ford, I will take the form back. I didn't really want to turn it in. It's okay. I will keep it in my documents. Just please let the officers know that it has to be charged. I can't do anything without it. I gave her the form back and Sergeant Moreno was notified. This entry is for documentation purposes only. And then they have some other stuff. She refused an evening shower. But that's the part I wanted to hit, is that, like she was complaining about, like she kind of called, like she said, better not happen. And the judge assured her, this laptop will be charged. You'll be able to use it from this hour to this hour. She has no control. She can't have any wires. And unfortunately, her computer was not charged, which sucks. I think it sucks. All right. Next up, we have our notice of appearance from the new lawyer for Sarah Boone. This lawyer is James Owens. He enters his appearance as counsel on behalf of the defendant, Sarah Boone. Let's take a look at his website. Let's do a kind of deep dive here. So first off, I know, let me look at the questions because you guys have probably already asked, but let me see here. Hi from the UK, Tilly Cat. So Sarah Boone filed it, but it says it was filed by a non-party. I don't think that's correct, Maxos. I don't think she filed it, because if she filed it, it should stay there. She's allowed to file motions. Even if they don't make sense, she's allowed to file motions. And the court said it was filed by a non-party. Miss Boone is the definition of a party to this case. I don't know. It was very weird. Maybe she did, maybe she didn't. But this was the question I figured came. Chris K, there you go. Thank you, sir. Peter, is this the know your lawyer guy? No, it's not. But it is James Owens. It is a private criminal defense attorney in Florida. And I do not know him personally. I have not had a chance to talk to my dad, ask if he knows him, or Pete or JD or anybody like that. I haven't asked if any of them know him. From Milton, Florida, which is not anywhere near us, but we have cases in that area. And this is the situation that he's presented with. Sarah Boone's case, all of her lawyers. Oh, good question by Marie. Will she be able to keep the laptop? She can ask for it from the judge. The lawyer can even ask for it. It's not guaranteed to her basically as a right. But at this point, let's talk about what we think the judge is going to do when we get there. Okay. Okay. So let's take a look at James Owens here. This is his homepage. Not a ton to it. Why should you choose James Owens? A guilty conviction for criminal charges can potentially ruin your future. You need to know that your criminal defense lawyer is looking out for your best interest at all times. James Owens provides tremendous value to his clients. 35 years of experience in the courtroom, knowledge of both sides as a former criminal prosecutor, convenient virtual consultations, personalized legal strategies. Attorney Owens has taken over 100 jury trials to verdict. He'll be your strongest advocate in court and offer unrelenting representation on your behalf. There's no case too complex. James Owens has decades of experience representing clients facing a wide range of criminal charges. Turn to him for assistance if you've been charged with, and we have Sarah Boone's charges here. So that works. From bail hearings to plea bargains, all the way up to trial, Attorney Owens will be with you every step of the way. He'll change the evidence presented by the prosecution to give you the best chance at a reduced sentence or drop charges. Will that be part of the discussion here for Sarah Boone? We know that she was going to potentially talk to the state about a plea deal. Let's go to his About Him page. Okay, this is it right here. Text me today. Don't text him. Don't bother him, please. This is all public, by the way. He puts this on his website. His Florida bar number. He's licensed to practice law in Florida since 1986. He was a prosecutor in Pensacola, 86 to 89. So usually most prosecutors' office make you give a 3-year commitment. Looks like he did something like that in Pensacola, and it was right fresh out of law school in 86. He was the elected public defender in the First Judicial Circuit from 2009 to 2012. That's kind of interesting. I have a lot of questions with that. So that's cool to be the elected public defender. He obviously has experience as a court-appointed lawyer. It doesn't say he worked for the public defender's office at any point. So from 89 to 2009, I wonder what he did. It says he practiced criminal defense for 20 plus years. It's 2024, so it's been 12 years since he was the public defender. So at least part of that time from 89 to 2009, he was a private criminal defense attorney, I assume, maybe the entire time. It's interesting to go back into being a public defender after being a private criminal defense attorney. I know a couple people that have done that for interesting reasons. And then why did he stop in 2012? Did he run again and lose, or did he choose not to and go back to private criminal defense? You would assume the money's better in private criminal defense. And I would say assume because not all lawyers get clients. So then you can make more money as a public defender if you're not getting any clients in private practice. He's handled over 100 jury trials, handled cases in Escambia, Santa Rosa, Okaloosa County, Florida, which is where he was the elected public defender. I mean, that seems like a pretty good resume, right? He's prosecuted cases. He was an elected public defender and private criminal defense. Seems like about as good of a resume as you can hope for somebody coming in to this case to represent Sarah Boone. He'll know what he's doing. He'll know what to do. All of these situations that Sarah Boone has been in, trying to figure out what to do and what motions to file, he will know. He will have done it before. He has experience in that. J. Michael RN, thank you so much for gifting 10 Lawyer You Know memberships. That's awesome. All right. So Mariah Johnson said you need a playlist for this case, trying to catch up on the shenanigans. We have a full playlist of this case. So check it out. It's the Sarah Boone playlist. And let me know if you can't find it or if there's an issue, then we'll try to figure out what the problem is. Okay. Amanda K said, is he doing it for free? Let's wait and see if we get any indication in the first motion that he's filed. The judge gave in and let her get her own lawyer. So she's always, you cannot remove a person's right to pay for and hire their own lawyer. The only right they can, the only right that can be removed from them is the court appointing and the state paying for a lawyer. So she can go get her own lawyer. A lawyer could represent her pro bono, or she can pay a lawyer. She has a right to pay a lawyer. And no surprise here. What did we think he was going to do, folks? Motion for continuance. We knew this was going to happen. We knew that if she got a lawyer, she would try to continue the trial. The judge has given every indication he will not continue this case again, no matter what. So many great questions coming in. I'm trying to star them while I'm reading. Okay. So let's read this, and then we'll talk about what we think is going to happen. Defense motion for continuance. Comes now the defendant, by and through the undersigned attorney. Rule 3.190F of the Florida Rules of Criminal Procedure, and requests this court to grant a continuance of the 3-week jury trial set to begin on October 7th, 2024, and alleges the defendant is set for trial by jury on October 7th of 2024. The defendant has just retained defense counsel, and a notice of appearance was filed on Friday, August 30th. We read that notice of appearance. He was retained. To me, that indicates he is being paid. But it does not mean that, right? You can retain somebody for free. So he could be working pro bono. That's all the indication we get. So we don't know the answer. Maybe he's doing it for publicity at this point. I don't know. That's his prerogative if he wants to do that. Maybe he's getting paid some nominal amount. Maybe he's getting paid by her fans in a GoFundMe account. I know it's not actually GoFundMe, but maybe somehow somebody's sending her money and that's what she's using to pay for him. 38 days remain before trial. It's not a lot of time to catch up on a very serious case like this that's been around for literally years, but Sarah Boone's had an opportunity to get a lawyer over all these years. The court has found that it's her fault. Multiple lawyers, I'm not going to say all 8, but multiple lawyers left working for her. So you cannot, as a criminal defendant, create situations to force a continuance when nobody else wants one. There's a victim in this case. His family deserves justice for what happened to him. The state can't just keep this case perpetually on the docket forever. The judge, the people in our community, right? The public has a right to move these cases along and not just have these cases sitting there forever. They're paying for her room and board, for all these lawyers for her, paying a prosecutor to prosecute her, paying law enforcement to work against her. So you can't just continue a case forever. But 38 days, it's pretty unreasonable to expect somebody to prepare for trial. But wait, there's more. Defense counsel has met with the defendant 4 times. I was surprised to hear that. October 20th, 21st, 26th, and 27th. So I've been in situations like this as a prosecutor, seen some of it as a defense lawyer, and you know how this stuff works and how judges deal with this. I expect, while the judge may not ask this directly to him, if you were meeting with her on August 20th, why did it take till August 30th for you to jump on the case? It's 38 days. It could have been 48 days. And now it's between them what their financial arrangement is. If the lawyer had to talk to her a few times, see if he believed her before he took the case. You don't have to take the case the first day you talk to a client. All that's well and good. So Bodie asked, what is an elected public defender? So in Florida, the state attorney and the public defender, the top dog and top lawyer in each of those offices is elected. He was elected to be the public defender, the elected public defender, just like we talk about the state attorney that people vote for and that wins the election. That's the head prosecutor. He was the head public defender. So the way judges look at these things is, yes, there's 38 days. Maybe there could have been 48 days if you started reading, if you started meeting with her 10 days ago on August 20th. But another thing, I said October. Yeah, sorry, August. Clearly says August. And I'm saying it's 10 days ago. So he met with her in August of 2020. Sorry, August 20th of this year. Let's slow down. The judge is going to look at this and say, sir, James Owens, you know this, private defense attorney, 100 jury trials, elected public defender, former prosecutor, been doing this for 40 years. You know that you took this case and it was your choice. You're a private criminal defense attorney. Okay? This docket is very public, right? All the dockets here are public. He could have looked up any criminal case he wanted to and seen the public docket besides things that are obviously sealed. But this case is very public. It's out there. You're going to know how many lawyers she went through. The fact that the judge said she forfeited her right to court-appointed counsel. Number 3, that he said he wasn't going to give her any more continuances. Number 4, he knew when the trial date was when he filed his notice of appearance. Judges, think about those things. You took this case, sir, knowing all of these details. So there is an element to this is what you're signing up for. And additionally, if he says he'll do it and the judge doesn't continue it, and then he says he's off, is Sarah Boone going to say, now that's a reason I need a continuance? Because that's not fair either. Is this a setup to buy more time? Is he going to quit in a month? Because that's not fair either. And I'll also tell you, sometimes judges like to do things like this. Well, sir, Mr. Owens, I'll allow you to come on this case. I'll grant you a short continuance. You will not be allowed to withdraw before trial. Because there's a different relationship with a private attorney than a court-appointed public defender. Court-appointed public defenders, they have a choice. They sign up for it. They're put on a list. But it's kind of a forced marriage, right? This is something that both of them are choosing. And obviously, if there are ethical concerns or something illegal is going on, he'll let him out. But irreconcilable differences, or we can't work together, or she's rude to me, or he's mean to her, the judge isn't going to look kindly on that because of everything they know, everything they're doing of their own volition at this point, and they're choosing to enter into this agreement, knowing all the landmines in this case. During these meetings, the defendant disclosed potential exculpatory evidence on her phone in the possession of Orange County Sheriff's Office. Evidence includes photographs, videotapes, calendars, text messages, notes, and witness names and numbers. This evidence will potentially corroborate her anticipated battered spouse syndrome defense under Rule 3.201 of the Florida Rules of Criminal Procedure. Undersigned counsel has spoken with numerous potential expert witnesses covering a range of possible defenses. Counsel is also actively vetting several additional experts upon directives from interested parties. So, he's done all this work. He filed his notice to appear today, August 30th. But he's met with her 4 times and he's talked to numerous potential expert witnesses about what they could potentially testify to. Isn't that interesting? Did he wait to file his notice of appearance today because there's a hearing on Tuesday and we need to continue it? Has he been working on this case without filing a notice of appearance? I'm not accusing him of that at all. I'm just saying if things are happening in order to make it seem dire and that they can't prepare and that they need to have a continuance, this is kind of how you do it. Now, I would not ever accuse a guy like this of doing it. Lawyer for 40 years, elected public defender, former prosecutor. I'm not saying that. But Sarah Boone, to me, has seemingly wanted to extend this case and continue to push the can, kick the can down the road. Let's answer some of your questions. Go ahead and hit that like button, everybody, if you guys haven't already, and subscribe to our page. She agreed to pay him if she wins. This is the worst agreement you can ever make in a criminal case. I also believe you cannot make payment contingent on victory in criminal cases. I have to look that up. It's been a while since I've looked that up, but I don't think you can do that. I don't think you can say, I'll charge you X amount if I win. I have to look at that. It's a bad move for lawyers anyways. I thought she was indigent. Well, she has been declared indigent. And this is going to be a very good question, Amanda, in a minute when we get lower in this motion for something he asks for that we're going to talk about. A-Care. Given her history and the late date he's coming on board, will the judge allow him to withdraw if history repeats itself? Well, A-Care, that's a great question that I've already kind of jumped into. So potentially it's possible, but I think it will be harder for him to withdraw than any other attorney before because he is entering into this case with open eyes and an open mind, knowing what he's getting into. And I think that's something the judge will make sure. FYI, on the Markel playlist, there's a golfing video. All right. Kelsey, we need to maybe take a look at the playlists, I guess, to see. Maybe let's put on our list to run through the playlists and make sure they're accurate. She'd already met with him when she filed to dismiss. I still find it hard to believe if I hear it in open court or from a judge or something that she actually filed that motion to dismiss. Okay. Right now, I'm not so sure. Will she be shackled at the table now? It's a good question. She can still ask to not be. But it's not as guaranteed of a yes as it was before. But since he's already determined she's not a, risk of violence or flight, I don't see why not. How will this change all the new rules, allowances that have been adjusted for her when she was defending herself? So potentially she won't have access to the documents or computer in the jail, but I think her freedom to move about the courtroom, meaning not shackled to the ground or handcuffed, is still going to be the same in trial. I don't think she's going to be handcuffed, and maybe she can still just do the shock thing. Bet she's pledging her expected movie deal money. Any chance he's doing it for fame? Sure, there's a chance. How can you tell that he's a public defender versus working pro bono? So his website says he is a former elected public defender from 2009 to 2012. So he's not a public defender anymore. He's a private practice attorney. But he used to be a public defender. Could this end up interlocutory appeal for a continuance? Highly unlikely. Highly unlikely in this situation. Peter, did you say you're familiar with this judge? Yes. This judge, yes, not this lawyer. The judge's order specifically said the case will not be continued for any reason except the extraordinarily good cause, and such an extraordinarily good cause shall not include retention of counsel. I get it. I agree with you, Jacob, completely. The judge has already said no continuance. I will just tell you from my experience, judges have still continued cases even after they said no more continuances. Sometimes over my very stern objection and sometimes at my request because things happen. And I get that he's already said this is not a things happening type of situation that will make me continue it, but I still want to see how it works and what happens. If there is there physical monetary money number when the government draws the line? Thinking outside the box, the longer the case takes, the more money the government officials could make or not make, aka when is enough enough? So for public defenders, it's a flat fee, as we talked about in the last video, which I think you were in. As far as like paying for court officials, judges, state attorneys, no, there is no number. They actually don't make more when a case goes on. They get paid what they get paid, their salary, whether they're handling one case or 1,000 cases. But realistically, if you're putting a lot of time into this case, you can't put a lot of time in getting justice in other cases. So that's how I would look at it. Azam, 420,000 subs. Yes, we hit it. 500K by the end of the year. That is quite a feat. If we can do it, everybody subscribe. And maybe we can do it. That would be amazing. All right, let's get back to the motion to continue. It is the professional opinion of counsel that the retention of one or more of these experts and the development of the aforementioned defense is a crucial and necessary component of the defendant receiving full and competent representation and due process under the law. Based upon the conversations that have occurred, counsel has learned that proper diagnosis and development of said defenses requires time, not only for administering appropriate testing, but also the necessity that any expert testifying on behalf of the defendant be given adequate time to establish a trusting relationship and then be allowed to apply the analytical tools to the information developed from interviews with the defendant and supplemented with historical and documentary information from third parties. The process, as described by undersigned counsel, by renowned and respected experts, cannot be accomplished in the time available before trial, particularly given the JAC ministerial hurdles, which must be cleared when dealing with an indigent defendant. So we're going to answer a couple questions here. But first, he's talked with these experts. It seems like there's something there, but they need to develop a rapport with Boone. They need to get information from her, go look at historical data, and put together this report. Multiple lawyers have said this is necessary for Sarah Boone. This is something obviously Sarah Boone wants to do as a defense. This is obviously important to the case. Some would call it the entire case. If you're going to admit you committed the criminal act, but you have an affirmative defense that makes your act not criminal, that's the entire case. So this isn't just there may be exculpatory evidence on her phone, like he said. I don't know how much water that holds, but there may be evidence that will help a battered spouse syndrome, and that's the exculpatory evidence. That's more important. So I know the judge said, I won't continue it even if you retain counsel. But will the judge actually say, you can't get this expert, you can't go with a battered spouse syndrome defense, I won't allow it? Is he really going to say that? Because if so, and that's the defense you want to use, it's almost 100% chance you lose without that defense. Because you've got to put the state on notice if you're doing that. So that's the big question before the judge. Is he really going to do that? But then we get to the JAC ministerial hurdles when dealing with an indigent defendant. So, a couple questions here. If she's paying him, this lawyer, why can't she pay for costs? If it's pro bono, Why doesn't he say that? It'd be a locked and loaded JAC is then going to keep paying for her experts. But he doesn't say that. So the question is this an automatic thing? Will JAC automatically continue to pay for this stuff? And the answer is it depends, and it's possible. But he's going to have to file a motion to make sure they're still going to pay for this stuff and explain to the court why she still needs JAC and why she's indigent. Not necessarily what the financial agreement is with the lawyer, but just because she has private counsel does not mean she is no longer indigent. Samantha asked this great question. If she gets a private lawyer, and then does the public defender's office still have to pay for any experts? Or do they not have to pay for any experts? It depends. And it seems like this is something that she is still going to request. And my guess would be the answer is going to end up being yes to this, that they still pay for these experts. Oh, Fawn Fogo said, look at the envelope for the motion to dismiss. It was filed by someone from California. Okay. So even less likely it was Sarah Boone, right? Thank you, Fawn, for that. Fawn Fargo. Tangling with Gina. Did Ashley B claim battered spouse in her case? Yes. Yes. So basically, let's keep reading here. Notice of intent to rely on battered spouse syndrome defense must be filed 30 days before trial. The notice must be filed by September 7th, 8 days away. And he's basically saying that's impossible. I need to file it. I need time to file it. So this goes back to, well, let's finish reading before I do that. Scott W. said, Scooby-Doo ending. At the end of the trial, they ripped the mask off this new lawyer, and it's Robert Tellis or Daryl Brooks or Ted Bundy. I love Scooby-Doo, and my son's in the Scooby-Doo age and still loves it. It's just the best mystery machine. And those, what is it? Those mangy kids and that mangy dog or something like that. All right. The defendant has been deemed indigent for cost. The defense will need government funds to assist in paying experts in the field. Defense motions will need to be filed concerning the potential Brady material. The defendant has the right. Yeah, I mean, if they have information on her phone that they're hiding that is Brady material, obviously that's going to be a big issue. Is the judge not going to allow him to do that? Now, it's a little speculative that it is actually on the phone. The defendant has the right to be represented by counsel of her choice. The defendant attempted to solicit private counsel after the court's order dated June 28th. The defense counsel responded to her advertisement and was retained. He was responding to her advertisement. Really? Wow. Those meddling kids. Yes, thank you. I knew you guys would come through. Wow. He responded to her advertisement. That's wild. The defendant is not trying to delay the proceedings or abuse the process by retaining counsel at this late date. He knew that this was going to be a question not only that the judge would have, but the public would have. The defense certifies this motion is made in good faith. Then a little memorandum of law. The Sixth Amendment to the United States Constitution guarantees that any person brought to criminal prosecution in a federal court must be afforded the right to assistance of counsel for his defense. As the Supreme Court recognized in Unger, a district court's denial of a motion for continuance may vitiate the effect of this fundamental right, meaning if I can't be effective because you won't grant a continuance, you have in essence not allowed my client to get effective assistance of counsel. The matter of continuance is traditionally within the sound discretion of the trial judge, and it is not every denial of a request for more time that violates due process, even if the party fails to offer evidence or is compelled to defend without counsel. Contrary-wise, a myopic insistence upon expeditiousness in the justifiable request for delay can render the right to defend with counsel an empty formality. The right to the assistance of counsel could not only reaches the trial stage, the right to assistance of counsel not only reaches the trial stage, but it extends to the sentencing as well. Further, the Supreme Court has stated that implicit in this right to counsel is the notion of adequate time for counsel to prepare for the defense. The prompt disposition of criminal cases is to be commended and encouraged. But in reaching that result, a defendant charged with a serious crime must not be stripped of his right to have sufficient time to advise with counsel and prepare his defense power. Wherefore, the defense would respectfully request the court consider this request and grant the motion to continue. So let's talk about this for a second. Number one, this couldn't be more opposite of the motion to dismiss that some random person filed saying violation of speedy trial. It's like, no, actually, we want to continue it again. And this is why the speedy trial is a complete non-issue in this case. The defense continues to ask for continuances. And of course, she waived her right to speedy trial. Number two, this is an example of a lawyer laying it on thick, putting the pressure on the judge, saying, Judge, you're taking away her right to assistance of counsel and her right to effective assistance of counsel. You're not allowing me to prepare this case the way it needs to be prepared. That's putting the pressure on the judge. Now, I'll tell you, this is not going to be the first time that the judge is going to see a criminal defendant either hiring a lawyer or switching lawyers right before a trial date in an effort to continue the case. And it's the same exact kind of argument you'll see here that other lawyers will make, and it'll be true. And whether or not it's an intentional setup by this lawyer or the defendant, it could look like that, and it's not allowed. You cannot game the system by switching lawyers or hiring a lawyer at the last minute, knowing they can't prepare, and therefore forcing a continuance and forcing the judge's hand. And at some point, just like the court did, the court is not afraid. At some point, enough is enough. You got to cry uncle and say it's over. No more continuances. No more free lawyers. Will the judge do that here? And it's also been no secret throughout the entirety of the case, and I've been wrong so far. I like to point out when I'm wrong because whenever I am wrong, I feel like I learn a lot and I try to figure out what did I see differently or how do we view this differently. But I have kind of assumed this entire time that the court was going to grant a small continuance at some point. Either you start the Monday after Thanksgiving and you're done before Christmas, or you start November 1st, so you're done before Thanksgiving. But doing that October trial date built in some small continuance opportunities and still getting this trial done and to verdict before the end of the year. And I actually still think a last day of November, first day of December trial date would give an extra 60 days to this lawyer. So now 98, 100 days to prepare for trial, which is enough time. And again, he's making the choice to come on this case. You can't say, I'm only going to come on the case if you continue it for a year, Judge. It gives him more than enough time to have the JAC hearing, which they can expedite, get the funds, put the state on notice, filing the notice of intent to use the battered spouse defense. It gives them plenty of time to do all that and still give a small continuance. Now, it's interesting because the court has already said no continuances. Will he go back on that? And once you go back on it once, are they more likely to file for more continuances? Now, if he does, I think he'll put more qualifications in there like Sarah Boone. Even if you and this lawyer break up, no continuances, you're going to trial. You probably will not be able to withdraw, sir, because it'll put her in such a bad position. So since you're choosing to take this case, you're going to try it on December 1st or whatever day it is. That could be something he does. Or he could continue it into 2025 and do what lots of judges do and just let him kick the can down the road. Because again, we don't want to create appellate issues. We don't want to create an unfair trial if we can avoid it. What do you think is going to happen? Kelsey, throw up a poll. Will this case be continued? Will the trial be continued? Yes or no? I can't wait to hear what you guys think. It's meddling kids. Yes, thank you, Chris. Does the court keep track and produce to the public her monetary figure spent? They should. No, but judges are tracked on how long it takes cases to get to trial, cases to get resolved. Their docket, people track that though. So that's interesting. What will the prosecution think about this? Honestly, they'll probably object because they know the judge doesn't want a continuance. I don't think they'll be overly bent out of shape if the judge continues it a month. They probably don't want him to continue it till next year because, again, they're making plans. They're trying to make sure that They get all their cases tried and they've got victims that they're trying to get justice for. So they really don't want delays. I don't like the term free lawyer. They ain't free to the taxpayers, guy. Yeah, to me, John, I'm paying for her lawyers. No, I get it. I get it. Free to them is what I meant. And that's the point, is the judge is like, listen, you get this benefit of this free lawyer free to you. Don't squander it. Don't spit in the face of that benefit. Steve, what would you say the pluses and minuses are professionally / career-wise to this or any defense attorney accepting this case pro bono or otherwise? So I have never, Steve, been of the effect, and I learned from my dad. So, I think people are biased in the way that they learn and kind of grow up. My dad never would have done it. Never would do it. I never would do it. I can't think of a situation where I would do it. But at the same time, I take every one of my cases free or contingent on victory, but not on publicity or not on fame. From my perspective, if I can work and build and make a case worth what it is or add value to a case or try a case, I love taking a percentage, and the more the client gets, the more I get. I love that type of situation. So from my perspective, I think that I'm cool with contingency fee cases, but doing something just for fame, to me, I don't see that working out very often. Sure, it can. But in the criminal defense world, you do something like this and other people know that you did it for free. They may ask you to work for free or think it's unfair that you did one for free and not their case for free. I see issues with it, but there's also criminal defense attorneys that have made careers, that have started podcasts, that have gone on news stations because of how good they did on a high profile case. So I can see, both sides of it, just never something I would want to do personally, but I don't think it's unethical. I don't think there's anything wrong with it. I think it's a personal decision for the lawyer. And when you have the ability to have your own law firm in private practice, you get to make this choice. You've earned the right to make this choice. Could he have no cases or noted? It's possible. I have no idea why he took it. Honestly, I have no idea. Imagine how many letters he's gotten since August. He just wanted it to stop. She wore him down. That's a good question. I wonder how it all did come together, honestly. Charlie, thank you so much for gifting 10 memberships. Sue said, off topic, would you look into the situation of Fulton County with the YSL case when the contractors of the jail have not been paid over $1 million and the guards walked out yesterday? Sue, it seems like you could talk about that. Do you have a YouTube channel that you could talk about? Former Warden Sue, I believe. Okay. So poll results, almost 2,000 votes. Will the case be continued? 69% say yes. 31% say no. So it's pretty even split. And usually I try not to tell my opinion before you guys vote because I don't like to affect the vote. I said yes, so maybe that's weighing it a little heavier on the yes, but a split chat here. Some think that the judge is going to stick to his ground and say, no way, no more continuances, especially not for retention of counsel. And that's exactly what you did here. So we are not going to allow you to force my hand and continue this case, Sarah Boone, just because you hired a lawyer. And my position is it has less to do with her hiring a lawyer and more to do with her getting the expert for that affirmative defense. Yeah, I know. That's what I'm saying. I'm assuming that I affected the percentages. That's my point. So from my perspective, I think that this one could go either way and I'd be okay with whichever way it went. Not an even split. I know I'm not saying, okay, let's use our listening ears. Okay. I'm saying I usually have an effect on the chat and on the votes if I give my opinion. I did give my opinion here and I said yes. And so I think it maybe weighted a little bit more towards yes. So while it's not an even split, it's probably closer to even than it looks on the results. That's all I'm saying. Regardless, there are people that have that see it going either way. Sarah isn't quite OJ Simpson though. Oh, nowhere near. Nowhere near. He'll get publicity, but yeah, it's not that kind of a case. Oh, or is he bored? I don't know. I think it's either it's a case, he's a criminal defense lawyer, she's paying him, or he's doing it for the notoriety. Those are the two reasons I think. James Owens has 19 current cases. So I don't think there's any way to see that or know that publicly. Okay. So if you're saying you've found 19 cases of record, did you look at all the jurisdictions across the state? Would be my first question. Number two, he could have out-of-state cases. Number three, he could handle cases in other practice areas. A lot of lawyers do that, especially solo practitioners. Number four, he could represent clients pre-arrest, as we often do. If they're being investigated or they're worried about getting arrested, they could have a lawyer. So he could have more than the publicly reported cases. There are now in civil cases, that's a huge percentage. Sometimes 50% of the law firm could be pre-suit cases, so they wouldn't be in the public record. So that's really might be a misnomer, but also 19 big cases might be a full docket for him. You never know. You never know. There was something else I was going to say. Dorothy said, is she laying the grounds for an appeal? I think that she already would have had these grounds for appeal. This basically fits into the box of appeal of you forced me to not have a court-appointed lawyer. And that's the major appellate issue. Now, that appellate issue basically goes away. And that's why I'm saying if I'm the judge, I'm doing my own work, right? I'm doing my own negotiating and trying to create a result. And while that might sound bad, the result I would try to create if I was a judge is an appeal-proof verdict. Whatever that verdict is, I don't care if I'm the judge, right? I'm not trying to force a certain verdict. But if I can get rid of appellate issues and all I have to give, right, a quid pro quo, all I have to give is a short continuance, I would do that. Give a 1 month continuance. The guy's got 68 days now. He can file his motion. He can get his expert. All the stuff about court-appointed counsel maybe goes away. Maybe Sarah Boone's learned a lesson and she'll be more respectful and nice and helpful to this lawyer that she's chosen. Maybe she's learned something in this process of how hard it is to represent herself and she doesn't want to go back there. Maybe the judge molded her into a better defendant and maybe a better person. Who knows? And maybe this will work, a lawyer that wants to be there. Jamie said, this defense attorney is well respected. We should commend him for doing what no one else wanted to. He may just be the one who believes in her constitutional right to counsel. I think every defense lawyer believes in her right to counsel. I don't think you have to take this case just to prove that you believe in her right to counsel. So I'll just say that. I don't know him. Maybe he is very well respected. The fact that he got elected as public defender, that's great. That's a big accomplishment. So I agree. And I hope that she is respectful to him and understands the experience and education he brings to the table. I confess I lean with you, Charlie. See, that's all I'm saying. There's nothing wrong with that. Like, I try to make arguments. I try to make plausible, logical decisions and arguments here. So I get it. I get it. Tell me you're a parent without telling me you're a parent. Yeah. Of a 8-year-old who doesn't listen well sometimes, right? I voted yes because I think the judge will tell the attorney he cannot ask to be removed. It's possible. Afton, does she still get to see all the evidence? I mean, this is are they going to do some kind of hybrid? I don't think so. I think her lawyer will go view the evidence and then talk to her and meet with her. Is she going to force her way in there potentially? You saw what happened with Tellus. He was representing himself, then he wasn't. And it was kind of like a hybrid deal. He argued some in front of the judge. He stood up at counsel table. He testified as a narrative, which you would do if you represent yourself mostly. So sometimes these hybrids are created, especially when people represent themselves at some point throughout the process. Jenny, if she gets a continuance because she gets a shrink, it could be years. Well, the shrink would be there specifically to, the shrink is only there specifically to work on the battered spouse syndrome and see if she fits the bill, look at the evidence, put a report together and testify. It wouldn't necessarily be a shrink to try and help Sarah Boone get over any mental health issues she may have. Let me see if there's anything else. There was something else I wanted to say or I wanted to point out. There are like a few points that I like to bring up with you guys that I know that you would find interesting. I don't make an outline. I should make an outline before I do these videos, but I never do. And I know you guys will bring the good questions always. I rely on you. You're my crutch. You, the chat, a great crutch. But yeah, seems like a good attorney. Seems like somebody who wants the case, wants to work with her. Seems like somebody she wants. So hopefully it works out. Hopefully he does a good job. Hopefully the judge makes the right decision, whatever that may be. And we get to trial this year and it finishes this year. We get a resolution, a verdict, and it's as appellate proof as possible, which means she gets a fair trial in front of a fair and unbiased jury. Is there anything like Dunning-Kruger with regard to taking a case, learning a little, think I could do this, only to evolve into a valley of despair? So there are probably some references there I might not understand. But I do think that seeing how hard it is and seeing how much she doesn't understand, that's the other thing is, I've said it the whole time. It's really hard for a criminal defendant to come do this themselves. And for her to try to figure out how to get an expert, how to talk to them, how to retain them, how to ask JAC for enough money, that's so hard. So if the lawyer does nothing but that and gets her through that process, I think it's a benefit. And I think the judge should try to make that happen. Even if he says, hey, you've got 38 days, I'll give you a hearing on 31 days before trial so you can do this and you can establish the battered spouse. I'll make sure that you have an expert that can talk to you and deal with this and get this done in 38 days. Dorothy, being a narcissist does equal battered wives syndrome. The evidence outweighs her defense, right? I want to wait to see how it's all presented, right? I mean, from my perspective, the state has a lot of evidence in this case. The videos she has on her phone are pretty bad, but there's a lot of stuff we probably don't know. So we're going to have to wait and see how it's all presented at trial. Right now, she's presumed innocent. And if any of us had a vote, I hope we would vote that she is not guilty because the state has not presented any evidence in a court of law. Won't the prosecution bring their expert in to talk to Sarah? So yeah, they'll be, and that's why you have to put them on notice. So you tell them you're going to do battered spouse, you get an expert, they get an expert. Everybody gets to interview Sarah Boone and say, she does fit the bill, she doesn't fit the bill, just like any other expert. Can you hire an attorney to only get a continuance? No, absolutely not. You can't do anything just to get a continuance. You cannot have dilatory tactics where you're just delaying the case. That is unethical. There are rules against that written by the Florida Bar. I was actually on the rules committee a couple years ago when we wrote even harsher rules that you can be sanctioned as a lawyer if you or your client knowingly do things to delay a case on purpose. All right. Well, folks, that's all we got. Man, was it an interesting update. This is moving fast and furious. We'll see if things slow down now that you got a lawyer trying to continue the case. But thank you for joining me. Please hit that like button if you don't mind. And make sure to subscribe to our page. And Jen thinks she will get a continuance. But until next time, I am out of here. Thanks for watching another episode of The Lawyer You Know. If you enjoyed the episode, please hit the thumbs up and share with your friends who may be interested here on YouTube. And don't forget to subscribe. You can also follow us on Instagram, Twitter, Facebook, and TikTok. And don't forget to check out the Lawyer You Know podcast with new seasons dropping every quarter. If you have a case you want to talk to us about, if it's a personal injury case, wrongful death, catastrophic injury, car accident, or slip and fall case, please email us at lawyeryouknow@gmail.com. And of course, all these links I just mentioned are included in the description below on this episode and every episode. So until next time, this is Peter Tragos, The Lawyer You Know.